Along with our co-counsel, Outserve, we represent a number of transgender people who are currently serving in the military or wish to join, as well as 3 organizations, Gender Justice League, the American Military Partners Association, and the Human Rights Campaign. This case started when President Trump announced on Twitter last July that he was reversing the military's own policy and banning transgender people. Since then, thousands of brave transgender people have continued serving their country with distinction and honor, despite the nightmare of being treated by their own president as second-class citizens and soldiers. We ask the court today for a final judgment in this case because the record is clear and the issues are ready for decision. The government had the burden today of demonstrating even one good reason to single out transgender soldiers for discriminatory treatment, but the government did not produce one valid excuse, not one credible reason for this discrimination. What the record shows is that thousands of transgender people have served our country successfully and with honor for more than a year, since the military ended its earlier discriminatory policy. Discriminating against transgender soldiers only undermines the military by harming unit cohesion and morale and driving qualified soldiers out of service. That's precisely why the military ban was ended more than a year ago. Dozens of high-ranking former military leaders concluded through a careful process of study that everyone who is able to serve should be given that opportunity. And that is exactly why it's time to end this ban once and for all. Just like all the other service members, transgender service members risk their lives to protect and defend the Constitution and the freedoms that we all enjoy as Americans. Lambda Legal will fight with our clients to ensure that transgender people are themselves protected under the system of laws and that they work so bravely and honorably to defend. We are optimistic that the court will rule in favor of our plaintiffs and find this ban unconstitutional, so that the thousands of transgender people who have endured this discriminatory targeting by their own government can get back to serving their country honorably and bravely.
Thank you. Now we'd like to ask Connor Callahan, one of our plaintiffs in this case, come on up.
Hello, my name is Connor Callahan. I'm 29 years old and currently work as a public safety officer at a college in North Carolina. In Lambda Legal and Outserve-SLDN. Man as my true and authentic self in 2014. I have known for some time, since I was 13 years old, that I wanted to enlist in the United States military. I love my country, and I consider it my personal calling to serve. In fact, I have started the process of enlisting. I'm willing to sacrifice even more for my country. But because of this ruling, I have been forced to consider a future in which I am unable to serve. I already work in law enforcement, and there is nothing about being transgender that makes me less qualified to serve in the military. We need a definitive ruling from the court to allow me to pursue the career I am fully fit and qualified to have. I am hopeful the court will do the necessary and just thing and block this ban for good, so I can focus on enlisting and in pursuing the career in life I've dreamed about since childhood. Thank you.
Now I'd like Catherine K.
7 years remaining until retirement. I intend on serving every single one of my remaining days within the military. Regardless of whether this policy that was announced Friday or a new policy or something completely different, We do not deserve the stigma that was placed upon us by saying that we are second-class citizens, that we're somehow inherently less valid or less able to perform our duties than any other service member. We stand and we fight. We are already here serving as soldiers, sailors, airmen, and Marines and Coast Guardsmen. We deserve the right and the privilege of continuing that service.
And I'd ask Peter Perkowskit, Legal Director at Outserve-SLDN.
Good afternoon. I'm Peter Perkowskit, the Legal Director of Outserve-SLDN, along with Lambda Legal, one of the co-counsel in this matter. We don't represent just the plaintiffs in this case. We represent all LGBTQ service members, including some 15,000 actively serving transgender people. And we represent their families, and we represent veterans as well. And three core military principles come to mind, regardless of what happens today, and they are this. The first is, no one gets left behind. The second is that we'll fight to the end. And the third is, we got your six. We're here for you. We're here for you all, and we're gonna take this to the end. Thank you very much.
Thank you. I now ask Lauren Baker, Assistant Attorney General, State of Washington.
Good morning. Bob Ferguson was unable to be here in person, so he asked that I read the statement on his behalf. I would like to thank Lambda Legal and Outserve-SLDN for their partnership and advocacy. I joined this case on behalf of the thousands of transgender service members who serve or have served their country with honor and distinction. Banning transgender individuals from serving based on anything other than their ability and conduct is discriminatory and illegal. More than that, it's wrong. Our arguments are strong and the evidence is clear. Transgender Washingtonians who want to serve their country and state deserve a resolution on the constitutionality of this ban. The court has already found that the ban is likely unconstitutional and blocked its implementation. I am hopeful that it will permanently end this effort by granting our motion for summary judgment. Thank you.
Now I'd ask Danny Askini from Gender Justice.
Sure. Hi everyone, my name is Danny Askini. I'm the Executive Director of Gender Justice League here in Seattle, Washington. I think, like many of the folks here today, what we heard in the courtroom was a very skeptical judge who has already blocked the implementation of this ban. I know many people have been focused on the new memo that came out on Friday. Those issues were not necessarily raised today, and that's because they are a post hoc argument, meaning they came after the original ban. And all of the memo and justification that you heard the government make today and continues to make about transgender people's inability to serve will be wrong-minded and found to be false. And we're really grateful to be here with Lambda Legal and Outserve and our partners HRC and all of the plaintiffs. Thank you.
And finally, we have Chris Sgro, Communications Director at HRC.
Good afternoon. My name is Chris Sgro. I'm the Communications Director for the Human Rights Campaign, the nation's largest LGBTQ civil rights organization. And I'm proud to stand here on behalf of HRC's thousands of transgender members across the country. I want to thank Lambda Legal and Outserve-SLDN for representing HRC, American Military Partners Association, the Gender Justice League, and the brave transgender people who are serving or wishing to serve their country. Today, around the globe, thousands of transgender Americans are serving this country with bravery and distinction. Countless more are enlisting or planning to enlist in our armed forces. And yet, this past Friday, under the cover of darkness and in an act of cowardice, Donald Trump and Mike Pence doubled down on their hateful, discriminatory, and unconstitutional attacks this policy is rooted in nothing more than the dangerous personal agenda of the president and vice president. It's unconstitutional, animus-fueled ban that only serves to hurt our nation's service members and undermine our national security. The despicable actions of the administration have consequences for trans people in and out of the military. It is part of a the bully in the White House has emboldened bullies in their classroom and neighborhoods. Since taking office, this president has sought to license discrimination against LGBTQ people in our military, our government, our schools, and in hospitals. They've targeted Muslims, people with disabilities, immigrants, people of color, and women for discrimination and unfair treatment. But they will not succeed because we are here to stay. Our country and Constitution are stronger than this regressive, impulsive, and disgraceful president and the anti-LGBTQ zealots propping up his administration of chaos. As a former member of the North Carolina legislature, I've seen firsthand the consequences of anti-transgender discrimination. I saw how our leaders' bigotry hurt our state and community, and that bigotry rightfully cost politicians like Pat McCrory their jobs. Standing before this courthouse, we have a message for Donald Trump and Mike Pence. When politicians come for our community, we will take the battle to the courts, we will march in the streets, we will come for you on Election Day, and we will not relent until these hateful policies and the leaders who push them are relegated to the dustbin of history. Thank you.
Thank you. Now, if you have some questions, we will try and get them answered.
Yes, I had a question for Lamont or Natalie. Could you just give us an overview of the rulings or proposed rulings and motions that are in the pipeline and how the arguments
Yeah, so the only motion that was pending today was the plaintiff's motion for summary judgment. On Friday night, defendants filed a bunch of documents, including a motion to try to dissolve the preliminary injunction and for a protective order. And so the court simply asked for further briefing on those topics. So the court did have some questions and ordered more briefing to flesh it out, but we'll work swiftly to put that information before the court. And although this might take a little bit longer than we'd hoped, we're optimistic the court will ultimately agree that this ban is unconstitutional. It always has been.
Natalie, I mean, given that the judge wanted to confine the arguments today to the motion summary judgment briefing, if she rules just on this topic, what's the practical effect? Is she essentially, she sides with you blocking a policy that's no longer in effect? Is the government just going to say, that's fine, we have a new policy now, it's materially different from the old one?
The judge requested further briefing, so we'll be addressing all of those concerns, but our position has always been that the harms that our plaintiffs suffer were the same as when they were announced on Twitter as they are today. Making slight changes in the policy in its final version does not render it constitutional.
But couldn't you then have to file something new if the administration says that's no longer in existence?
No, our motion is ripe. We have standing. We don't have to file another motion.
Can you take me through the memorandum they put out on Friday? The judge was pretty adamant over and over again saying, this was filed after the fact, cannot be used. But then at the end, she said, okay, you have 7 days. Can you explain what the 7 days will be allowed for them? Are they allowed to use the memorandum and the arguments proposed in that as part of what they file in the next 7 days? Is it now on the table?
I don't think it's on the table. It's that post hoc report is legally irrelevant. Defendants may continue to claim that it is relevant and that it could have justified their decision, but that will legally fail. So we are going to brief these issues. The government had to have a reason when it discriminated against transgender people, had to have a reason at that time. They can't later on come up with a reason.
There was a point in there, it seemed like a significant kind of shifting point, just from us watching, where the judge, she kind of addressed, do you want to sort of focus on this state procedural issue, or do you want to kind of attack maybe the fundamental, and there was kind of a pause and then a decision. No, this is a kind of a fundamental case that we're bringing forth. How important was that sort of pivoting moment right then?
I don't think it was a pivoting moment. I think both the state of Washington and the individual plaintiffs win summary judgment procedurally, but we also want the court to get to these very important constitutional claims. and to rule that the ban is unconstitutional.
So how does this case play into kind of the constellation of various cases that are around this issue? There's lots of balls in the air right now.
4 federal courts have issued preliminary injunctions enjoining the ban from going into effect, including in Perkowskit. If in our case we obtain a final judgment, that would be a final judgment declaring the ban unconstitutional, and it would apply nationwide.
Are there any other imminent hearings coming up in the other jurisdictions that you know of?
DC, I think, is the next. They have a hearing today, but I don't think that it's. Sorry. And Danny Skinny. I think that DC has a hearing today. They actually had one this morning, but I don't think that it was a motion for summary judgment, so it wasn't on a final ruling, which is what we've asked for. The judge is more interested in getting an update about Friday's memo and understanding the implications for the case in DC. But there will be more proceedings. I think what's important to know is that the other cases will continue to proceed forward, regardless of what the decision in this case is, and there will be more hearings around the country.
Then it would have to eventually go to the Supreme Court soon, right?
That all depends on the Department of Justice, which will have to make a determination about whether they want to appeal the ruling here. So it's hard for us to say. But a final judgment here is a final judgment.
Anything else? Okay, thank you very much.